Well, hi everyone. Today we're talking about meeting with a family consultant at the family law courts, and the type of meetings we're talking about are those meetings that take place pursuant to Section 11F of the Family Law Act, which I'll go to in just a little bit of detail in a moment. Firstly, about me, my name's Shaya Lewis-Dermody. I'm the Principal Solicitor of the Family Law Project, which is a specialist and socially responsible family law firm. You can find more details on our website. Now, for the purpose of today, as I said, we're talking about meeting with a family consultant under Section 11F of the Family Law Act. So we're not talking about meetings for the purpose of a family report. We're talking about something that's quite different. So hopefully you enjoy this recording and it gives you just a few practical tips to put you in a better position for when you do have that opportunity to meet with the family consultant. So the meetings that take place with a family consultant under Section 11F, they can be ordered by a judge of the family law court, being the Family Court of Australia or the Federal Circuit Court. And we find that a meeting and an order that's made commonly, particularly on the first return date in the Federal Circuit Court, where the judge will make this order for the parties to attend upon a family consultant. One of the questions we often get asked as solicitors is whether or not our clients can take family members or their support person with them to meet with the family consultant. Generally, our response to that is, look, unless it's been specifically ordered by the judge and that the court order says, a partner or a particular family member is to be involved in the process, generally the expectation is that family members or support persons will not actually be involved in the court process in terms of meeting with the consultant. That said, it can be useful to have a support person with you. Just be mindful though that it's unlikely that they'll actually participate in the meeting with the consultant, and just think of it in terms of them being there as a support person to sit with you in the waiting area and so on. Will your lawyer be with you? Well, this is another really good question. The way that these consultations are arranged is that it's only the parties that actually attend upon the consultant, and your lawyer's not actually present. So don't have any unrealistic expectations as well that your solicitor will be there with you, and that's why it's another really good idea to speak to your solicitor before you attend the meeting, just to get some really good feedback that's relevant to your particular circumstances and your particular case. And in terms of what actually happens at the meeting, I think it's really important to know that the family consultant will have access to all of the court file, so they should have read all of the court documents before you've actually gotten to the meeting with them, and so they'll have a bit of an idea, or a good idea really, around what the issues are and what the position of the parties are, at least in terms of what their documents are saying. You'll find that the consultant will probably have some very direct questions for you. It's really important to remember that this isn't FDR, it's not a family dispute resolution process. The consultant's not a mediator there, so they're not there to try and mediate and resolve all issues. And unfortunately, we find a lot of clients go off to these meetings with the consultant with the expectation that it's going to be a bit similar to an FDR process, which it's not necessarily. Having said that, the consultant will speak to both parties and will ascertain what their positions are, and if they really are as polarised as what perhaps their documents might say. The consultant will speak to both parties, ascertain how polarised they are, what their position is, may give an indication of how genuine their concerns are, and effectively what they're going to do is they're going to make some recommendations to progress your matter and suggest some ways forward. And our experience is, at least in the first instance, the parties will generally find themselves being in a separate room to each other, and effectively the meeting will be run as a shuttle meeting whereby the family consultant will go back and forth between the parties. It may be in some circumstances that at some stage towards the end or during the conference that the consultants of the view that it will be more useful for both parties to be in the same room together, but that's at the discretion of the consultant. And like I said, our experience is generally the parties will at least begin the conference in separate rooms. Now, if you have concerns for your safety, so for example, if there's an intervention order in place, or you've raised some serious concerns about family violence in your notice of risk document and or your affidavit material that's before the court, then you certainly will be in a separate room. And I'd also advise speaking to your solicitor about arranging a safe room for your court proceedings generally, because at some stage you will have to go to court and go into the courtroom and appear before the judge. In those circumstances as well, your solicitor should be able to assist you to arrange a safe room, and that's where security will also provide that additional security and peace of mind for you. In terms of children's attendance, this is a really, really important question to ask. And it's important that clients are aware of this because, of course, we're talking about parenting proceedings. So there's often this expectation that children, of course, they would attend, and of course, the family consultant would meet with the children. Well, it's not necessarily the case. So there's two types of these 11F meetings that the court may order. The first is called a non-child inclusive conference, and the second is a child inclusive conference. So we tend to find that where the child is a bit older and certainly is of an age where they can express some views or there's a particular reason for them to attend, then the order will expressly say that it's child inclusive conference. And in those circumstances, the consultant will also meet separately with the child or children and have a chat to them and report back to the court as to what those views are as well. Younger children, it's very rare that they'll actually attend the court and attend upon a family consultant for the purpose of the 11F meeting. So one of the roles of the family consultant, and this is perhaps, at least by the judges, seen as their most important role, is they'll provide a memorandum back to the judge. Generally it's just a couple of pages, but it confirms what was said during the meeting with the consultant, and it makes some recommendations as to how the matter can be progressed. It's really important to remember this, and it's particularly important to remember that anything that you say during the meeting with the family consultant is not confidential, and that's another reason why it's a good idea just to perhaps reread your documents before going to the meeting, or have a chat to your solicitor about your particular circumstances if you're concerned about something that might be raised during the meeting and you're not sure how to respond to that or deal with that. But everything that's said is not confidential, and it may be reported back to the judge by way of this memorandum. The memorandum can be very useful. It's not binding, so the consultant can't make any decision, it can't make a judicial determination, but certainly recommendations will be made. So this 11F memorandum, it gets placed on the judge's file, so he or she will certainly read that before your matter's next in court. It also gets distributed to the parties, so your solicitor will get sent a copy, as will the other party or parties' lawyers. And in an example with our clients, we forward them straight away by email to our clients so that you have a copy for your records. It's really important that you have a read through it. If there's anything in there that perhaps you disagree with, then it's a good idea to make some notes of those and give your solicitor some instructions about that. Distribution of the memorandum is to parties only. Just be mindful, under section 121 of the Act, you're not allowed to provide copies or distribute that memorandum to anybody else. And and you can get in some trouble for doing so. So please ensure that you keep it to yourself. Any questions, then of course talk to your solicitor about your particular circumstances. So whilst talking about questions, if you do have any, feel free to get in contact with us. I've just popped the contact details there on the last slide. Feel free to give us a call, send us an email, check out our other ways of contacting us via our website. Otherwise, thanks so much for listening to this recording. All the best for your meeting with the family consultant if you have one coming up, and all the best in terms of your family law matter generally. Thanks so much. See you later.